This is Net Video. I'm Jason Romney, coming to you from Sydney, Australia at the offices of Sydney law firm Gilbert Tobin, where we're joined by Michael Williams, who is a partner at Gilbert Tobin and in charge of the Kazaa case. Michael, welcome to the show.
Thanks very much.
Michael, you've had a number of intriguing experiences in running the Kazaa case, not least of which must have been appearing in the witness box. Why don't we start off with that experience?
Well, it's not something that one expects when you're acting as the solicitor on a case, but as you're probably aware, we started this case with a series of Anton Piller order executions. And in simple terms, what that means is we apply to the court for effectively a civil seizure order, and that enabled us to capture information from computers from many locations around Australia. It was a pretty ambitious application because the court permitted us to go to 13 sites in 3 different states at the same time. And the first person who was under attack for that kind of order was myself.
So what is the timeline we're talking about here?
Well, we started the case on the 5th of February 2004, and we executed these orders on all the different sites on the very next day. Now, just to put that in perspective, that represented sites at universities, at internet service providers, and at the homes and offices of those that we identified operating the Kazaa system. So it was quite a big enterprise. It was all done on a single day, which was a Friday, and the last site was left by some of the members of my team at about 1:30 in the morning.
It's almost like a military exercise. How many people are in your team?
Well, at that time, I brought a lot of other people in to be able to execute the Anton Piller orders. So I think we went to approximately 60 or 65 people at the time. In terms of the core team running the case, it's changed over time, but it's anywhere between 3 or 4 and 8 or 9.
How would you now describe the issues involved in the Kazaa case?
Well, I think they're pretty fundamental on a number of levels. Firstly, one of the issues clearly is to what extent can people trade and distribute copyright protected material on the internet? Now, I think there's a lot of assumptions that have been made about the internet in the past, whether or not it's a lawless zone or a jurisdiction outside of legal jurisdictions, as some commentators earlier wrote. I think the Kazaa case is one of the leading examples of the law actually trying to catch up with the rate of change of technology and the rate of uptake of the internet.
When did Kazaa first come to your attention?
Well, I actually have quite a bit of history with Kazaa because back in early 2002, I was retained by the US recording industry and the US motion picture studios, that is the big movie studios and the large recording companies, in connection with the US case. And that's the Grokster case, which people know about today. When that case was filed, it was actually filed against the then operators of Kazaa and against Grokster and Streamcast. That case has resulted in a series of applications made around the world to collect evidence, and I was retained to collect evidence from certain individuals and companies located in Australia. So that was my first brush with it, which was seeking orders in the Supreme Court to enable us to capture information and to require the deposition of individuals for the US case. My next brush with that was in about 2003, when in about mid-2003, certain aspects of the Kazaa operation appeared to move to Australia, and that's when we began our investigation that led to the filing of the case.
What would you say people should be thinking about as a legacy of the Kazaa case?
Well, coming back to what it perhaps represents in copyright law, I think it more than anything else demonstrates that courts and court systems have the capacity to respond to challenges like posed by Kazaa. So you've got a system with hundreds of millions of people who are subscribers, with billions of files being traded per month. Many thought at the time it was impossible to bring anything of that size before any court in the world, but I think we've demonstrated that you can. I think the second thing is that the turning a blind eye to what happens on the internet just because most people use the internet from their bedrooms or their homes. And again, I think the case represents a pretty salutary lesson about how just because it's happening in the home doesn't mean it's not considered very serious, and it may not infringe people's rights or in fact be a breach of the law. Now, a couple of years earlier, we ran a major investigation into another form of internet piracy in Australia for the recording industry. And that was an operation that resulted in police raids in Perth, several other states, and then Sydney, and the conviction of 3 students for setting up a pirate website. And again, I think that was probably the first real wake-up call for people that just because you're a student, because you're doing it in your spare time, possibly as a lark, that it doesn't mean that you're not also coming to the attention of the law enforcement and may be pursued for very serious offences. And in that case, each one of them received an 18-month custodial sentence, which was suspended on certain conditions. The magistrate warned that the next people along the line wouldn't receive such leniency.
That's quite a severe sentence, though.
It's a very severe sentence, that's right. It was certainly seen as being a significant sentence at the time, but since that time around the world there have been quite a number of people who have been not only convicted of similar offences but in fact jailed. So what we're increasingly seeing, I think, around the world, whatever view many people in the community think of it, is the investigation and the prosecution criminally of people for file sharing.
There are quite a few people who think that they can't be detected when they use peer-to-peer networks. Is that true?
No, it's not. And in fact, that's one of the greatest misconceptions about using the internet. Far from being a place of great anonymity, it's actually a place where every step you take, by and large, you leave an imprint both on your own computer, but more importantly on a series of other computers and networks to whom you connect. So it's quite a frightening thought, actually, that every step you take on the internet could be used as a piece of evidence in the event that you're ever investigated or prosecuted. We find time and time again that many of the people who are pursued in these actions almost boast of their anonymity and the fact that they're beyond investigation, only to find out all too quickly that that's not the case. Kazaa argued the same in the case, and that proved to be quite unsuccessful. It's a bit of a lesson, I think, in terms of how little anonymity people have on the internet. And that's only a lesson being learnt very late in the piece.
What is the actual method by which people leave that trace?
Well, it's in many different ways. Firstly, the whole act of internet browsing involves your computer communicating with a series of remote computers, and often through a series of intermediate computers and equipment as well. So in simple terms, if what I understand to be visiting a website is in fact my computer communicating, requesting information and sending information backwards and forwards with another computer. Now the effect of doing that is that my computer and that computer make a record of the transaction. Now most websites have attached to them logs which are ordinarily activated, which means that all the traffic backwards and forwards is logged within a file, which is usually stored and increasingly saved for law enforcement purposes these days, or can be accessed by copyright owners. And I've done that in about 5 cases. We've accessed log files and demonstrated that we could actually identify what people were doing and how they were visiting websites and what they were downloading from those websites. Now that's on a small scale, that's just with a website. Extrapolate it out, it becomes a much more significant business when you're dealing with a peer-to-peer system.
There are undoubtedly a lot of people, some of whom will be in responsible, perhaps professional roles, who at some point in the past downloaded music or movies. Should they be concerned now?
Look, I wouldn't have thought so specifically. I think anyone who's doing it on a substantial scale and anyone who, notwithstanding the cases and prosecutions, keeps doing it should be concerned. I think people who've dabbled with it in the past have probably worked out there's not a lot of future in that kind of activity anyway.
The underlying peer-to-peer network technology is being used for legitimate purposes in new media phenomena such as the BBC's integrated media player, or the IMP, which is supposed to be delivering to the TV licence holders in the UK 40 years worth of BBC content. Are there quite a variety of authentic, legitimate ways in which peer-to-peer networks should be used?
Look, there's a couple of misconceptions about peer-to-peer. The first one is that it's a new phenomenon. It's actually not. In fact, the whole peer-to-peer model was really the very first model on which the internet was actually constructed. Web browsing and client-server relationships were the more advanced form of internet activity after that point. So we've seen something of a cycle in returning to this notion of peer-to-peer traffic. There's undoubtedly many systems that operate according to that definition as peer-to-peer systems, and they represent legitimate distribution models. But I think it's not so much is peer-to-peer capable of or in fact used for legitimate purpose, it's what in fact are different services predominantly being used for, and how are people actually extracting content from other services. What we're actually seeing is a resurgence of client-server models, and we're actually seeing a resurgence of straight websites because while there are positives of peer-to-peer architecture, there's also negatives. One of the great negatives is if you don't happen to have the other peer online at that time, the file's simply not available. Whereas most internet users expect that if you go to a website, the files will be available and wouldn't wait around if they weren't. So in a sense, it's almost like having a system of hundreds and hundreds of websites which may or may not be there at any given hour of the day, which may not inconvenience the average user. So there's certainly other architectural considerations that come to play.
So how would you sum up the legacy of this case for the media, entertainment and technology industries globally?
Well, I think, as I said earlier, I think there's been certainly a view expressed previously that a system as large as this, as multi-jurisdictional as this, really can't be brought before the laws of any country. And I think that's not right. So that's one of the legacies. I think the second legacy is there was a lot of talk before the case was run about really conjecture about whether or not the architecture of the system provided a defence to copyright infringement. In other words, if I didn't have a web client-server relationship with my users, but I had a peer-to-peer relationship and there was an element of decentralisation, do I become liable? I think the legacy of this case, and coincidentally the legacy of the US Grokster Supreme Court decision, is that the exact architecture of any system is not as relevant as the activity behind it. And you know, it's been said before that it wouldn't be any more an excuse that the getaway car was a V6 rather than a V8 engine. After all, it's the activity in question which really matters.
The world's attention has just shifted to the issue of the Sony BMG rootkit software, which apparently opens up a hole in the name of legitimate copy protection for hackers and viruses. Is there any link between the two cases, or are they completely different issues?
No, I think they're different issues. Certainly from what I understand about that issue, like all computer programs installed on computers these days, they create changes in the computer registry and the underlying operating system. And that's one where people have used that as a Trojan horse to introduce viruses. But that certainly happens in the peer-to-peer context and in lots of other contexts as well. I think it's like any security breach on the internet. It's unfortunate when it occurs and people are scrambling to try and patch it up.
Is it your feeling that globally digital rights management is maturing into an accepted and effective technique, or is it still a hopeless shambles?
Well, I think it certainly is maturing, and it'd be too difficult to try and summarise where digital rights management is up to in total. It's very effective in many fields, and it's more difficult to implement in others. I think as a whole, it's moved from being an ideal situation to now a ticket to play in the internet space. So most content suppliers will expect and demand that digital rights management is protected, well, firstly is implemented, and secondly is protected and effective for the content that they supply. So I'd see it as a benchmark now for all content supplied on the internet in one form or another.
Michael, there's a lot of confusion in the mind of the public about how the different file sharing technologies fit together. Macintosh users use LimeWire and there's BitTorrent for both platforms. Are all these things the same, using the same technology, or are there nuances that lift some of them into a permissible realm, whereas others are more offensive from a copyright viewpoint?
Systems that operate on a peer-to-peer basis can vary considerably, and probably peer-to-peer has moved into its third generation. The first generation was really typified by Napster. Napster made a success of a system on a very widespread basis that most previously had not been able to do. The second level systems were the hybrids like the Kazaas and so on, which became super systems with hundreds of millions of users, and they differed, generally speaking, because they remotely located indexes. So in order to find files, you didn't go to one place, you went to a number of different places potentially. What we're seeing is a shift to a third generation of system. BitTorrent's an example of it, where you're almost finding a more localised architecture for the system at the same time as many of the features that you'd see on previous peer-to-peer systems. So what does this mean in practice? What this means is that there's a learning constantly going on amongst the software developers. We're also finding that policing internet sites and policing internet traffic in many respects is becoming more straightforward with these more localised systems like BitTorrent than it is with the systems like Kazaa, which are much bigger and more widely diffused. And I think that that's not the result that a lot of people would expect in using the systems and thinking that they've got the latest version, because the latest version I think has typically been sold as a very anonymous or very efficient way of defraying liability for copyright infringement. And in terms of liability for copyright infringement, I think the systems do create different issues. Fundamentally, use of those systems, I think, is being confirmed around the world as infringing copyright where unauthorised content's being distributed. I don't think that's really in question anymore. The question is more as to who it is who's behind the software, who may also be responsible in terms of secondary liability for the activities of users of the system. Now, the more localised the systems are, the more likely it is that there's some local host and local administrator who is that person. The larger the systems are and the more diffuse they are, like Kazaa, it's more likely to be the people who develop and supply the software.
In relation to this new phase of place shifting, where companies like Sling Media in the United States are allowing people to create an IP tunnel from the place where they receive their pay TV at home, for example, to their holiday house or to a hotel they're going to stay at on the other side of the world, so they get all their video content there distributed to wherever they're going to be. Are there legal issues there which are going to become perhaps a new hotspot?
I imagine there would be. One of the simplest attempts to do the same with music on the internet was brought to an end because the courts wouldn't abide people creating virtual collections of their music on the internet, even if you'd bought the CD. I think many of the arguments about how portable entertainment products are and the limitations of the law previously don't apply so much now, because you can go out and if you want very portable music or you want probably portable films in the not too distant future, you're going to be able to buy them direct from sites and download them, and you'll have rights to be able to create copies for a limited purpose and also to use it in one place or another place. And I think that's different when you look at the bundle of rights that you have when you buy a standard CD, which comes with certain advantages, but it also comes with a disadvantage that you can't just rip that CD for your own purposes. So you really, probably this is translating into commercial opportunity, But that's not to say that there aren't going to be legal issues surrounding each one, and I think that if you bought one of those items, you don't necessarily have the same bundle of rights as you do with the other. And so the same would be true, I think, with IP, this notion of IP tunnelling, or being supplied with a product at one place and then saying I want to be able to exploit it and use it wherever I like. I think that will come with a premium, and it won't be a function of being able to, just like anything else. I think it's like wireless broadband. It's not as simple as simply having the broadband to a fixed point, and those services come with premiums and with also conditions that attach. And you can't necessarily equate one with a fixed point service with a multi-point service.
People are observing that the songs that they can buy now for the first time on the Apple iTunes Australia store are significantly more expensive here than in the United States, for example. Do you see that situation gradually changing so that there's a parity of pricing globally?
Well, I think it's hard to single out one product and then try and compare the cost of it in different places. I mean, there are those famous studies about the cost of a Big Mac in all the different countries in the world, and you find that a Big Mac costs very different prices depending upon where you are. I think that's probably not surprising that music and CDs and basically everything else costs a different price if you buy it in the US as to Australia. It's never stopped people buying cars in Australia, even though they cost 2 or 3 times as much as they do in the States, and I wouldn't expect it to trouble consumers to pay the prices which are being charged by Apple here, any more than the other e-tailers of recorded music.
If we now go back to the start, to the Kazaa matter that you managed, you mentioned that there were numerous Anton Piller orders issued, and thus you raided a number of premises. Was that a very dramatic situation?
Well, it probably represented the high watermark, there's no doubt. I mean, we had executed a lot of Anton Piller orders during the preceding couple of years. We did it in relation to a number of different industries, but including for the music industry. But there's no doubt that when there's that many sites being raided at once, and there's that many people out in the field, it's quite a difficult enterprise to manage. But equally, it demonstrated its worth because the material that was captured was all live material, and it showed the operation of the system at many points all at the same time. So it could never be suggested that what we were seeing about typical Kazaa use was atypical or was influenced by what we were doing. We simply went to sites unannounced at universities, and we found people using Kazaa sitting at computers at the universities. So it was a very powerful evidentiary tool to be able to put before the court when we did.
Can you describe some of the lawyers and barristers who were involved in the case, the well-known ones?
Well, on our side we had specialists like Tony Bannon, SC, and Richard Cobden, and also John Nicholas. Now, I think those three are regarded as very experienced in the IP field and would be no strangers to most people who practice in that area. They're also very experienced counsel on the other side. Tony Marr and Stephen Finch were also in the case, as was Brett Walker. So it was a very large case from the legal point of view. We were, even though we were acting for the applicants in the case, we represented only a small component of the lawyers who were present, and the bar table was certainly filled on the other side. We also used live internet in the court on wireless systems, which was one of the first cases, to my knowledge, where that's been used extensively. So we're actually running Kazaa live in court, and actually using examples of searches and results appearing right in front of the judge at the time. And there's no better way to try and demonstrate the system than that. Even after the hearing took place, but before judgment, certain information came into our hands. Applied for Mariva orders to freeze the assets of Sharman, and were successful with those. I think it's probably a rare case in which you have both Anton Piller orders and Mariva orders, and if that rare case is this one, then so be it.
There must have been global media attention.
The judge set up the largest of the courtrooms within the federal court, and I think he did it with good reason, because there was a very large media contingent, and people came from all around the world to report it. Last time I looked, there were something like 1,000 major media hits around the world straight after the trial. So there was television coverage, of course, but perhaps more importantly, the case was being reported on a daily basis in some of the world's leading newspapers like the Times and the LA Times, the Washington Post and so on. I think that sort of demonstrates the significance internationally of the case, even though it was running in downtown, small town Sydney.
What do you think will be the next big show in town?
Well, I think we haven't seen the last of this case, and I don't think we've seen the last of cases that are dealing with internet piracy and really the distribution of content on the internet. So I fully expect there to be other cases that come after this. After that we filed the Kazaa case, we actually pursued a BitTorrent hub for the first time in Australia, and even though that case is settled, I don't think that's the last word on this kind of work that we're doing.
Michael Williams, thank you very much for joining us on Net Video today.
Thank you.
Control.